Welcome to the Facebook community, Entrepreneurs Growth Community. We are excited to have our two favorite lawyers on here talking about business law and what's the biggest issue when it comes to this pandemic. Let's get started. From Osuji and Smith Lawyers, we've got Charles Osuji, who is the managing partner and CEO of the law firm, and Amanda Ovaici, also joining us from the firm, talking about employment law, talking about vaccines. Charles, Amanda, thank you for joining me today.
Thank
Thank
you
you,
for having
Faisal.
us, Faisal. We really appreciate
So,
it.
Charles, I wanted to start with you about this because this is going to be a topic that we're going to touch on now, but it's going to get more and more media attention as the vaccine starts to deploy through the general public. Right now, the vaccine, because of where we are in the situation, is not being deployed throughout the entire community, only certain groups. But at some point, it's going to hit businesses. And a lot of business owners have been talking to me about a few things with the pandemic and its deployment of the vaccine. What are the legal obligations that employers should know about when it comes to having their employees vaccinated? Charles, what do you think?
Thank you, Faisal. To start off, is it interesting to know that there hasn't been any legally mandated vaccination campaign in Canada? This is all new, right? So we are more or less we're in an unknown territory in terms of what is mandatory, what would fly in terms of the Occupational Health and Safety regulation, what would fly under the Aboriginal Human Rights Act or the Kenya Human Rights Act, and all of that. So this is an unknown territory. There isn't really any template to deal with the situation that is ongoing right now. At the end of the day, the answer is going to be a little bit generic. It depends on the type of employer. It depends on the type of employment, right? For instance, employers that deal with, you know, older folks, health related employment categories, these are the people that could get away with mandated or mandatory vaccination policies, right? So long as the policies are very clear and communicated to the employees, right? So it all depends on the context, depends on the type of employment, depends on the objective of the employment and what the employer intends to achieve.
So when we talk about that there is no mandate or there is no real template, is are you referring to there's no precedent cases that we can fall upon? I know in other situations when it comes to employment rights, employers' obligations, and other cases in other parts of the world of law, we normally as lawyers, you normally fall back on precedent cases, maybe even as high as Supreme Court of Canada cases. Is that what you're referring to, Charles, as a template that we don't have one yet?
I was talking on a more broad general terms. However, we've been fortunate to get a template from, I think this happened in a case called Kirsan Care Nursing and Retirement Homes and Christian Labor Association of Canada. Is a COVID testing grievance. The employer obviously deals with older folks, right? Is a home care kind of situation where the employer set out a mandatory mask policy, mandatory vaccination policy, mandatory safety and precautionary policies in place. And one of the employees decided to challenge the policy and you know the employee maintained the position that the policies infringed upon their rights, right, the privacy rights and human rights and all that. And the employee was not successful at arbitration. The arbitrator said, "Look, the one of the arguments the employee made was that there wasn't any known case at the facility, right? And the arbitrator said, look, waiting for a case to happen is unreasonable. Waiting for someone to actually contract COVID-19 and die before this policy becomes reasonable and enforceable makes no sense whatsoever. And given the anecdotal evidence from all over the world with death in the states and all over, the fact that an employer that caters to older folks has set out a policy in place that deals with ensuring that individuals that are working with these older folks are constantly taking precautionary measures and taking on the vaccines when due that is reasonable. So the grievance was not successful, and the employer was successful. I think that is the one template I have so far. A lot is going to come out as things unfold.
For sure. Amanda, we've just heard from Charles about maybe industries that are catering towards older Canadians, more of maybe in the healthcare industry. I can understand that. Many of the viewers of this have different businesses. Some, I would say, are going to be exposed to the public. Let's think about restaurants, bars, grocery chains, so on and so forth, where you're still engaged with the public. And the question that many employers have is, can you force your employee to get vaccinated?
So we kind of spoke about this earlier, Faisal, but the favorite answer that everybody likes to hear from a lawyer is it
Right.
depends, right? Um, it's always subject on several variables. Notably, though, it is heavily influenced by the nature of the workplace and on the current existing policies the employer already has in place. Um, Mandatory vaccination policies may come up for the industries such as healthcare and senior living facilities. These places have strong grounds for implementing a mandatory policy vaccination, keeping in mind that industries that are exposed to the welfare and the well-being of a demographic that are very vulnerable right now to the COVID-19. Um, Likely, these places that are currently existing, so healthcare officials and like you already mentioned, Charles, people that cater to the elderly, they chances are already have mandatory flu shot policies that are in place. Um, for these industries, there is a case where employees refuse. There was an example of an employee's refusal to comply with the mandatory flu shot requirements, and it constituted a cause for dismissal. Um, the one case is prevalently from Ontario that a lot of provinces are currently referring to, and it's Barclay v. Mohawk Council. In this case, a nurse that worked at an adult care facility that took care of the elderly refused to comply with a mandatory influenza immunization policy because she stipulated that she's never had the flu and had a very strong immune system. This, however, was a necessary condition of her employment. It was already outlined in the contract and current existing policies, and said that the refusal to do so would result in their dismissal. So, because of the nature of this nurse's work and the employer provided evidence about the risks that the flu shot had on their residents, the very residents the employee had day to day interactions with, provided the employee was a nurse, it was proven that because of her education, she ought to have known of the risks. Um, and it was decided that the employer had a legitimate interest in the residents' well being and health. Therefore, imposing the vaccination of their employees was not unreasonable, and the termination of that employee's employment was upheld. Now, that's going back once again to the healthcare and individuals that take care of the elderly, right? Outside of those types of industries, there might be a case that could be made if we're talking about frontline workers that also just in their nature have exposure to individuals of a certain vulnerable demographic. Um, However, employers will be faced with greater challenges in implementing a mandatory vaccination policy on all employees. Like I said, although a case could be made for workplaces that are dependent on working close in proximity to one another, so like factories where subject on their age group, they're very close. Um, you could show in those cases that there would be a need for a vaccine, um, but it would be a heavier burden to overcome unless you could show that there was a undue hardship before it could overcome any accommodation challenges,
Yeah, it's
right?
it's interesting because when I look at, we talk about the healthcare workers during this pandemic, but there are a lot of businesses that were considered essential during this pandemic. And if you think about your grocery chains, me personally, I think that the employees of grocery stores and so forth should be put in same boat as healthcare workers to receive the vaccine. I can only assume what a grocery store or a company can tell their employees about having the vaccine because they're dealing with the public at close proximity. could this be an issue? And it's going to be very interesting. Charles, what rights do an employee have when it comes to this sort of situation where, can they just say, nope, I don't want to have it? Or what's the process, or basically, what are their rights as an employee?
So there are two categories of rights an employee would have under the circumstances. Number one would be privacy, right? An employee typically has rights to the confidentiality of their medical information. For instance, whether the employee has taken the vaccine, that is the medical information. When is the medical information, and what is the outcome of the test of a COVID-19 test. That is the medical information. So an employee does have the right to the confidentiality of such information, unless the legitimate business interest of the employer trumps the confidentiality or privacy rights of the employee. The second right would be the right to be accommodated, right? An employee has a right to be accommodated if accommodation becomes necessary due to the employee's medical situation. For instance, if the employee, falls ill at work or medically disabled, physically disabled, the employer has the duty to first of all understand the disability of the employee. And if the employer understands that, the employer has a duty to ensure that the employee is accommodated. However, the exception is where the accommodation leads to undue financial hardship on the part of the employer. In other words, the principal approach here is an employer shouldn't go out of business because an employee is sick, right? So there's a burden on the employer to establish that they, first of all, are aware of their duty to accommodate the employee. However, such an accommodation would lead to undue financial hardship. So those are the two major categories of rights or protections an employee would have under the circumstances.
Would this be, Charles, would this be similar to when cannabis first became legal in Canada and employers had some employers had the right to do testing to see if their employees were taking cannabis? Is this a similar kind of thing, or are we talking about something completely different now with this pandemic?
Slightly different. With respect to cannabis and all of that, the objective is to identify intoxicants at the workplace, right? And intoxicants in this case would be, the ones that we know, the marijuana and all of that. And the reason for that is to ensure that the employee's ability to provide excellent employment services is not fettered, right? Or influenced by these intoxicants, right? However, with COVID-19, it's slightly different, right? You're dealing with infections, you're dealing with actual risk to human loss of human life, right? So the urgency is a bit heightened with respect to COVID-19 versus the drug and alcohol policies that deal with intoxicants.
So Amanda, this show that you're both on is to not only educate and inform business owners, but also to give them some tips along the way. And I think one question I'd like to ask you on behalf of business owners is, what should businesses implement when it comes to now knowing the vaccine's coming? We have some headway. We've got some lead time now. This can't be a surprise. So what advice do you have for them on what should they be implementing in their businesses?
So there's several things that I think that some businesses should have already implemented from the offset of COVID. And having said that, having several conversations with a lot of them, they have not. So I kind of want to go back to that because moving forward, I think this should be an instrumental part of their day-to-day policies as well as upcoming contracts because you never know what the future has in hold for us. COVID could seize, and then we'll get hit again in another 2 years. I really hope that that doesn't happen, but yeah, I wish I had a magic ball that could foresee it, but you don't. So businesses should definitely have a continuity plan in place or a pandemic slash infectious disease response. Currently, in order to ensure that the company is in compliance with the occupational health and safety requirements, companies have an obligation to keep that open line of communication with their employees about the risk of disease, which include COVID-19. So you need to keep them updated on risks and tips to avoid contracting and spreading based on information on reliable sources. And that's really important now more than ever as we're transitioning back to the workforce. So a lot of people have been operating from home and virtually again in the last 4 weeks during this last shutdown, well, hopefully last shutdown. Um, so they need to be aware of implementing this going forward as more employees are coming back into the workforce. Um, so having said that, because it's something that's consistently and always evolving, it would probably be beneficial to have somebody that's on top of government advisories so that they can continuously update their team as the information is coming out and as it's continuously changing on a day-to-day or a weekly level. Um, Employers should also have reasonable controls in place to safeguard against workplace hazards. Does constitute as a workplace hazard, and what is considered reasonable will depend on the workplace and the environment that you're working in. So once again, we've given rather generic responses thus far. Um, so you'll need to determine the type of workplace that your employees are operating under, and that will determine what's required from you as an employer. So some of these, for examples, include having infectious control materials available, such as hand sanitizers and masks, advising employees to call in sick if they have any symptoms, rearranging the workplace to minimize physical contact, temporarily allowing employees to work remotely if they have concerns about operating from the actual workplace. And obviously, and this is a given, employers should continue to cancel any large work gatherings until notified otherwise. Companies should also consider updating their employee contracts. I know that some of them are consistently relying on their previous ones to onboard new employees, but new contracts should include conditions that comply with the OHS and employment standards and human rights laws, but that starts to define a few parameters regarding a pandemic outbreak or just in case of a pandemic
Can I
outbreak.
just ask a quick question there?
Um,
Either Charles or
yeah,
Amanda, either of you can answer this. So let's say I have an employee under a contract that was made pre-pandemic, and it doesn't cover for stuff like that because we never thought of it when we drew up this contract. Now we're in the pandemic, and we've got a couple of issues. We've got the pandemic itself, a wave coming back to where we have to go in and out of maybe the business back and forth, a vaccine on its way. Is it advisable to redo all the contracts for all the employees and get that covered? And can someone say, I don't want to sign a new contract, I already have my old one? Either or, Charles, Amanda, whoever wants to answer that one, go right ahead.
Right. So it depends on, in this situation, what needs to be updated is the policy, not necessarily the employment contract, right? So an employment contract deals with fundamental tenets of the relationships, such as compensation, hourly rates, title, position, responsibilities, and all of that. Those terms can only be changed with the consent of the employee because they are fundamental, right? But policies that govern the manner with which an employee conducts themselves at work and policies that are aimed at ensuring that the employer is up to date on maintaining their obligation to provide a safe work environment for the employees. Those policies can change from time to time at the instance of the employer. And if an employee refuses to sign those policies, that might be um, an instance of insubordination on the part of the employee, right? So there are two categories of changes an employer can make during the relationship. The first category is fundamental changes to the contract. If an employer wishes to reduce the compensation or increase the responsibility substantially, those are fundamental changes. An employer must obtain the consent of the employee and also ensure that there is a fresh consideration, right? Maybe give the employee a signing bonus or increase their salary in exchange for the promises to agree to the changes. But changes that speak to policies, conduct, and the way the employment relationship is governed, what to do, what not to do, those things change from time to time based on whatever is needed, especially given the pandemic that was not foreseeable, presumably at the time the relationship began. Those changes can be made without the consent of the employee. However, the employer must provide information to the employee about these changes. The policy must be effectively communicated, it must be clear, it must be reasonable, and the employee must acknowledge seeing and receiving and understanding the policy for it to be effective.
So as Charles was saying, we're not drawing up brand new contracts. It might just be an amendment to policies inside the business. Those businesses who don't have policies in writing should definitely do that.
Absolutely.
That's a good start. The conversation going now to the employer talking to his or her employees saying, "Hey, have you got the vaccine?" Is that allowed? Are we allowed to actually start asking those kind of questions? Because I understand privacy, but this is just people having lunchroom conversation. Is that allowed?
So I think it's really important that employers should keep in mind that asking an employee whether they've received the vaccination, despite every fiber of their being probably wanting to do so to ensure a safe environment for everybody, but requesting proof is a collection of personal information and triggers privacy considerations. So although the matter continues to unfold, it is recommended that businesses keep a close eye on the vaccination system implemented in Canada and Alberta, as the employer's obligation to ensure the health, safety, and welfare of its workers, as well as their clients, that their employees are taken care of, they have to be balanced with the employee's rights to privacy, um, as well as the industry's requirements and workplaces and the environment and everything. So I have a feeling, although we don't have a very definitive answer right now, as more vaccinations are rolling out, I do believe that the province as well as the country will start to offer certain regulatory or legislation that kind of governs this in order to facilitate and help businesses and employees to feel comfortable to coming back into the workplace, and for businesses to ensure that they're able to meet the legal requirements of providing a safe environment. But as of right now, like I said, I think both companies and employees should just keep a close eye as vaccinations continue to unfold. One of the primary things I think that both Charles and I have consistently emphasized today is that this information is generic and it's subject to multiple variables such as the industry, the type of industry you operate in, your environment, your workplace, and will also be impacted subject on current existing collective agreements that you have in place or contracts. So, in order to better understand individual legal position, as whether you're in a business or an employee, it's honestly, truthfully, really important to get a law firm and to seek out legal advice to review your matter, because we've given overarching statements which really are subject on tons of variables, and it's always good to get proper legal advice
Amanda,
before
do you have an
proceeding.
idea what law firm you could recommend to viewers?
Well, obviously, I'm biased. I love
Right.
Osuji and Smith, so I'll be definitely emphasizing them. We're a great firm, and one of the things that I will emphasize, Osuji and Smith, we're really good with things pertaining to business and employment law. That is some of our niches that we are excellent and we excel in quite a bit. So, I mean, obviously, that's one of the motivating factors of why we were chosen for this interview, and we'd be more than happy to assist anybody with their legal
Let's not
issues.
forget business owners at the end of the day. Charles also is a CEO of his company, and he wants to make sure that his business is growing too. So I'm glad that he put that pitch in there because that's what we want to see business owners doing, especially during times like this. I'm not going to hold you to this, Charles. I just want to get your opinion on it. Do you think the government can or will mandate people to be vaccinated to come into the office space or the workplace when this vaccine is available to the public?
I believe there's going to be some, excuse me, some level of requirement. I don't know what that will look like. It has to be customized. We can't have an across-board regulation here because of the variables that Amanda has spoken to a few times now. So there's going to be some requirement. However, like I said at the very beginning, we don't have a template for what's going on. There's no term of reference here. The government comes up with a regulation today, and then 6 months later, they're apologizing for the regulation. This is where we found ourselves, right? However, given the imminence and the danger posed by this disease and the economic disturbances the disease has also brought to the world, I believe there's going to be some level of requirement. The struggle is going to be to strike a balance between the employer's duty to maintain and ensure a safe work environment versus the employee's rights under some privacy legislations and right to say no and right to be protected under the Human Rights Act as well.
No, man, I want to ask you this, and if you want to throw it to Charles for more, feel free to do so. I'm going to give you the example. So both of my daughters are in martial arts. Right now, they are doing it by Zoom, but at some point in the near term, they will be back in the dojo to participate in that. Now, I know the vaccine's being deployed. Do I, as the customer's parent, have the right to ask the employer, have all your staff been vaccinated? Because I don't want to expose my children or myself to that. And if I have that right to ask, do they have the obligation to share that information with me as a consumer? Any thoughts about that? And if Charles, if you want to jump in on that, you feel free to do so.
So, I mean, I will push it back on Charles, but I foresee an employer has every obligation to keep their employees' privacy, their health records very private. Already making those inquiries to their employees is a possible of something that it starts to create privacy laws and human rights laws. So communicating that to a third party, I would probably advise most likely keeping it confidential unless you have your employees' consent. But Charles, can you foresee any other requirements or issues that might
Right.
govern that
Under
situation?
the Occupational Health and Safety regime, a third party, a stranger, a passerby, could actually report or complain to Occupational Health and Safety if they think or they have reasonable basis to believe that an employer or a business owner is not taking certain measures to maintain a safe workplace. And I'm going to extrapolate from that obligation. If a third person could do that, and in fact trigger an investigation by Occupational Health and Safety, by extension, that same third person could also ask the business owner, what steps are you taking? I've come to your workplace and I can see that some people are not wearing masks. What steps are you taking to ensure that the workplace is safe for everyone, including your daughters? There might not be a corresponding duty to disclose on the part of the employer, but there's nothing wrong with a third person asking that question because that same third person could, if not satisfied, reach out to Occupational Health and Safety on a confidential basis and complain about the workplace.
I can only imagine, and again, my head sometimes thinks on the worst case scenario. As we open up the economy, these business owners, and I'm thinking of brick and mortar business owners, have a lot going at them. One, they have protesters against this pandemic and masks and anti-masks and all that. They also have clients and customers who are scared or tentative coming back into the building. Number three, there's competition, and especially in a pandemic where the economy has collapsed, I can only imagine business owners might be ratting out other business owners when it comes to this type of stuff. So I could imagine my competitor going to occupational health and safety, coming back and saying, "Hey guys, these guys they're not following any criteria." And we may have, but it's still going to cause an investigation, which then deviates my time from running my business and dealing with that stuff, we'll call it. Um, Charles, let me go to you first on this one. What protection does a business owner have from other businesses and clients and customers we can't really do much with, but other businesses kind of just making it hell for you during this reopening of the economy? Can is there any case that we can actually go after those through lawsuits or cease and desist orders or anything like that? What kind of strength does a business owner have if these types of things are happening to them?
Right. Unfortunately, I believe the occupational health and safety regime does maintain some confidentiality of this complainant to maintain the integrity of the process, right? Because if there's a fallback to the complainant for whatever reason, then the complainant may be dissuaded from filing a legitimate complaint in the future, right? I think the filter here is the fact that the occupational health and safety is not going to lead to a conclusion with our investigation, right? If the investigation turns out that the business owner is actually, taking steps to ensure the work environment is, free from hazards and is safe, then that is victory for the business owner. So I think there's some discretion on the part of the occupational health and safety to also, not pay attention to certain complaints if on the face of those complaints there isn't really any credibility to it. So I don't know of the complainant, suffering some consequences unless it becomes very obvious that it was made out of bad faith and to hurt the business of the respondent.
So, Amanda, what I've heard and learned so far today was number one, make sure you have policies in place for your own business. Make sure that all your employees are on board and understand the policies that are in place and have been updated given where we are in this pandemic. So, put that in writing and make sure that every employee signs that document knowing of the new policy updates that we've had. That's number one. Number two, make sure that you are responsible for the health and safety of not only your employees but of your customers as well. So make sure you put that as a paramount. The third one is that this is going to be ongoing and changing. The rules as we see it today may be different a week, a month, 6 months from now, who knows? And so we need to be always or consistently looking for through to the government and other industry regulators to make sure that we understand what are the protocols. Have I missed anything beyond those learning outcomes? Is there anything else you'd like to add to my learning outcomes today?
And I would just say also, so you emphasized policies quite a bit. I'd also emphasize employment contracts. I think right now more than ever, it's time for people to review their current existing ones. Usually we recycle, and I know this as a business owner myself, we recycle contracts over and over again, sometimes without replacing them for years. Usually it's advisable to review your contracts every year, but now more than ever, we have conditions that need to definitely be updated. So I think business owners should be reaching out to their current existing um, law firms or Osuji and Smith to update those. The other thing is if you're planning on implementing a system where you want to make inquiries about uh, getting your employees vaccinated, or making the inquiries to your employees of whether or not they have been vaccinated, I'd say prior to you even remotely implementing that, you should be reaching out to a council in order to know your rights as per your industry, as well as to ensure that you're accommodating your employees appropriately and in conformity with the legal
Can I
parameters
just
that are
jump
out
in
there
there,
for
Amanda?
us.
You talked about redoing your contracts or updating your contracts for new employees. Many Canadians have been laid off or have been dismissed of their roles because of this pandemic. Coming back, if you are laid off, then you've been asked to come back. Is that a brand new contract or you're just reigniting the old contract? So I'm kind of, it's a two-part question. Do we have to redo contracts all over again when you bring back? I've never laid off somebody, so I don't know how this works. If I lay off somebody and I bring them back, new contract, or it's the old contract. And in that second case, if we are bringing people back, can we start a brand new contract, which includes these pandemic clauses that you're referring to?
I can deal with this. If an employee has been laid off, the relationship hasn't come to an end. It has been suspended, right? The employee remains an employee of the company. The only thing that is happening is the employee is not getting work and not getting paid, right? So the
Okay.
employee remains on the payroll. So once the employee comes back, you don't need to create a brand new contract. What you can do is to update the policies, right, for the employee. But if you wish to make changes to the contract, fundamental changes such as compensation, hours of work, place of work, responsibilities. Again, the caveat that I had indicated earlier was that the employer must obtain the employee's prior consent and ensure that there is consideration flowing from the employer to the employee in exchange for these changes, such as any signing bonus or an increase vacation, increase compensation, and all whatnot. Maybe in another segment we can talk about layoff. A lot of myth about it, but with respect to changing contract, the focus should be changing and updating policies. And back to Amanda's point, a business owner should be talking to lawyers at this point. If lawyers are not very certain about the state of the law, much less so the business owners, right? The business owners should be talking to lawyers, ensure that they are up to date in terms of what they should do and what they should not do. A policy cannot be enforced if, number one, it's not in writing, is not properly communicated, is not reasonable, and the employee did not know about it. I in my work, I see a lot of employers referencing policies from 2002, 2003. The employee didn't even say it, they didn't even acknowledge receipt. So it's going to be very difficult to enforce or punish an employee for doing something that has been prohibited in a policy that they didn't know existed.
So, Charles,
It's just
good
irrational. It
good
doesn't make any
learning for
sense.
business owners there is if you have a policy, even if it was written in 2002, to have your employees review it and sign that they've reviewed it every year potentially. Wouldn't that be a good step for business
Absolutely.
owners to look at? Yeah, and so that's
Absolutely.
something we can learn from. I think when we're going through the motions of running a business and you bring on a new employee or you've had an employee for 20 years, memories are not that great after 20 years of being an employee of what the policy was back in
Right.
2002. 19
Right.
years later, how do you expect them to know that policy or remember it or
Exactly.
recall it? And that's, I think, a good learning outcome. Both of you have been giving us some great information. And Charles, here's what I think is going to happen. Economically speaking, we're going to open up this economy and test it out. And I'm speaking locally within our province at this point in time. We're going to test it out. There might be, I call it the accordion factor. It's going to open up, close, potentially until this vaccine has been deployed and we've got quote unquote herd immunity. What's probably going to happen with many businesses is people being laid off, coming back, laid off, coming back. So I do want to bring you back on our show to talk about how do you lay off somebody, how do you bring them back, all the rules
Right.
around that. 'Cause I think that's very important. Unfortunately, we are out of time. Otherwise, we'd be spending a lot more talking about that. Both of you, thank you so much for joining me today. Amanda, I'm going to give you the chance. How does anybody watching this come reach out, both you and Charles, to get more information, legal advice, and maybe even update some of their contracts and policies?
Yeah, so they can definitely contact Charles. I don't have the number memorized yet. I'm terrible
Right.
with numbers, but you're gonna have to definitely call us directly at the office. You can ask for myself, Charles, or we have a phenomenal team, like I said, of lawyers that are well acquainted with employment and business law. We'll set up a consultation with them, and we'll literally walk you through your entire legal issue together. And if our consultation is sufficient for you and you feel like you've gotten enough of the tools and the issue isn't complex enough, you may or may not just you may have just needed the consultation. But then you could also have included help that needs revising your policies or your contracts, and all of our team is very well
Absolutely.
capable of doing
The
that.
phone number to call is 403-283-8018, or we could be reached at our website, www.osujismith.ca. Alternatively, just Google best employment lawyers in Calgary and check out for the top hits.
You've seen these two. Watch for them coming back in on our show. And don't forget, business owners, there's a bunch that we learned today. One thing that I've always said for decades now is get your legal advice independent to anybody else so you understand your rights and responsibilities. It is the right thing to do. This is not the time to cut corners because of cost or anything like that. It is worth the consultation because the impact could be tenfold or more to your business. So I strongly urge each and every one to get the proper legal advice as we go through this pandemic. Amanda, Charles, thank you so much for joining me today on the Exchange Live.
Thank you, Faisal. Appreciate it.
Thank you, Faisal. It was a pleasure for sure.
All right, I want to thank our guests for joining us today. Don't forget, I strongly recommend having that independent legal advice for you and your business. You definitely need this. And I want to thank all of you for joining us live on Facebook at the Entrepreneurs Growth Community. Take care.